When the prosecutor wants to use a secretly recorded phone call in a criminal case, what kind of notice does he have to give? To find out, you have to read People v. Myers, but it's 7 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on People v. Myers. This can be found at 2023 New York Slip Opinion 00691, published by the Court of Appeals on February 9th of 2023. It's a criminal case. The issue here is, when does CPL 700.70 require the people to turn over evidence of an intercepted call? The law in this case, a little bit that you have to understand, is that New York State takes telephone privacy extremely seriously. There's a constitutional provision in the New York State Constitution under Article 1, Section 12, along with the general Fourth Amendment rule about people's persons, houses, papers, and effects being protected. Also, in that same section, telephone calls, telephone communications shall not be violated absent a warrant. Okay, so it's very important. There's also a section of the CPL, Criminal Procedure Law 700.70, which says that contents, this is important language, contents of any intercepted communications or evidence derived therefrom may not be received in evidence at trial unless they're turned over and disclosed and given notice to the defendant within 15 days of arraignment. Okay, so that's what you have to understand. The third thing you have to understand is that if you make a phone call from jail and they tell you on the front end of the phone call that you're being recorded, then you have no expectation of privacy. It's not actually an intercepted call. It's just you have no expectation of privacy such that it can be used against you without a problem. Okay, so now let's go to the facts of the case. There's 3 things happening simultaneously, which makes this complicated. There's a fatal hit and run in October of 2015. The principal suspect identified by the investigators is DH. They talk to DH. He says, well, I know it was my car, but I lent it to my girlfriend that night. They talk to the girlfriend. She says, someone stole it that night. Okay, so DH is being investigated for a hit and run. Second thing that's going on is there's an unrelated investigation of somebody else named AC, where the New York Attorney General obtains a phone warrant, an eavesdropping warrant, to listen to his phone calls, to AC's phone calls. The third thing is there's a person named AJ who's in Onondaga County Jail, okay? And he makes a phone call from Onondaga County Jail where it says in the beginning of the phone call, your calls are being recorded and monitored. And he calls DH, okay? So now he's calling our hit and run suspect. And our hit and run suspect patches in AC, whose phone calls are being monitored by the warrant. And in the course of that conversation, DH hands the phone to his cousin, who's our defendant here, Myers. And Myers talks about the hit and run and basically implicates himself in the hit and run. The detectives at the New York Attorney General's office recognize the voice of Myers and call the investigators on the hit and run and say, I know who your person is. Get a copy of the recording from the jail, from Onondaga County Jail, because the call is being recorded 2 places. It's being recorded at the jail because there's no expectation of privacy there, and it's being recorded because of this eavesdropping warrant that the New York Attorney General obtained on AC. So the detectives get it. They arrest him. He's prosecuted. The people do not turn over the information about the eavesdropping warrant within 15 days. They don't do it. They turn over a copy of the jail call, and months later they inform the defendant about the eavesdropping warrant. The defendant moves to preclude, saying you violated 700.70 of the CPL. Trial judge says no, they didn't. Denies the application. The defendant's convicted. He appeals to the appellate division, and they affirm what the judge did. Goes to the Court of Appeals, and they reverse. They say that there's 2 things happening here. The phone call from jail was not an intercepted call because the sender knew he was being recorded, not intercepted. But the wiretap was an intercepted call. And because the evidence was derived from the wiretap, under the language of CPL 700.70, that had to be turned over within 15 days, and it was not. And they reiterate that when we're dealing with phone calls and we're dealing with CPL 700.70, people have to strictly and scrupulously comply with the 15-day rule. And because they didn't hear, the evidence is thrown out, due process violation, retrial. Too long, didn't read, People versus Myers. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.